Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon. We're happy to have you here. Sorry we aren't going to be able to come down and shake hands at the end, but you know you have our best wishes. We are happy to hear argument. Our first case, number 20-1690, Warfield versus Icon. Mr. Edwards? The floor is yours. Okay.
Thank you, Judge Motz, and may it please the court. My name is Chris Edwards, and I represent the appellant, Jim Warfield. The arbitration panel in this case did exactly what the parties asked it to do when it rendered a judgment in favor of Mr. Warfield. Icon asked the arbitration panel to apply North Carolina's employment at will presumption, while Mr. Warfield asked the panel to apply a just cause standard found in a 7th and 8th Circuit case, also applicable to the arbitration arena. With no North Carolina case directly on point, the arbitration panel permissibly concluded that Mr. Warfield had been wrongfully terminated. Icon asked the district court to vacate that award for manifest disregard of the law, and in so doing, asked the district court to treat the arbitration panel as a junior varsity trial court, to ignore its contractual promise to arbitrate, and to instead disregard the promise of efficient dispute resolution. The district court erred when it vacated the arbitration award, and this court should reverse the district court's judgment for 3 reasons. First, there is no North Carolina case on point, and so Icon cannot show that precedent compels a contrary result. Second, though Icon now relies on this court's decision in Raymond James against Bishop, Icon failed to educate the panel on the meaning of that case that it advanced in the district court, and so the panel did not refuse to heed the law. Finally,
so can you tell us a little bit more about your argument about Raymond James, because it seems to be the most telling case against you. And I've read your brief, but I wasn't quite sure what your argument is.
Well, I think there are 2 arguments on the Raymond James case. There's one on the substance of that case, and then there's one on the procedure, on the way Icon presented that case to the arbitration panel. And Judge Motz, I'm happy to address either one. I want to make sure.
I think that maybe in seriatim. In other words, okay, the substance of the case, and then whether they made the decision known, and I guess this is your claim, and the arbitration panel expressly rejected it.
Yes, Judge Motz. So turning to that first question about Raymond James, I think that the case is distinguishable. This court in Jones against Ansel says that the precedent has to compel a contrary conclusion. The Raymond James case does not do that. The court decided it on the last page of the decision. The court lists 2 factors. That is the voluntary, the at-will employment, and then Mr. Bishop's voluntary termination of his employment. He walked away from his job. And the court says, well, looking at those 2 factors, we decline to apply Agron and Lang on the circumstances of this case. I think it is debatable as to, the court didn't decide which one of those was dispositive. The court did not address, it addressed them in tandem. And so I think that what is preventing the Raymond James case from controlling here is that tandem decision between at-will employment and then the voluntary separation. Here, there's no dispute. Mr. Warfield did not voluntarily separate from Icon. He was terminated. And so,
well, was Raymond James a wrongful termination case? I don't think so.
Your Honor, it wasn't a wrongful termination case. That's exactly right. As we've pointed out, Raymond James starts, there are kind of threads of wrongful termination, but this court's analysis of the arbitration decision says there's no basis for this other than breach of fiduciary duty. If you look at the history of that case, actually, the wrongful termination claim comes up as kind of this Hail Mary pass in a reply brief. And so the court addresses it, but it's not really something that the parties focused on until the very last minute. And it's something that the court addressed, but didn't really need to, because again, the Raymond James case started out as a dispute about whether or not Raymond James had breached its fiduciary duties to its former employees by, quote unquote, the unauthorized practice of law. Even if the court were to determine that Raymond James controlled or could arguably control, I don't think the court needs to go that far. If we look even as far back in this court's decision in Remy against Payne-Weber, the arbitrator only has to do what the parties ask it to do. We see that principle applied in other cases. In the 3S case, 3S Delaware against DataQuick case, you know, the court discusses a statute of limitations defense that was not fully fleshed out.
And that was going to be my question, and I think that's probably where you're getting ready to go. But I think your argument is that opposing counsel did not make the panel aware of the Raymond James case for the proposition they argue now. Is that right?
That's right, Judge Thacker. The first time that ICON ever brought Raymond James to anyone's attention as dispositive, it was in the district court. And we can look at the record.
So counsel, I guess I don't know what you mean by dispositive, but I'm looking at JA 150, which is their trial brief, I think the arbitration brief, and they address the general proposition that North Carolina law is an at-will state. They address your argument that these 8th and 7th Circuit cases might provide some other way of looking at it. And then they say that Raymond James, shows that those cases don't apply here. They're not, collective bargaining cases like those, and that there's no express agreement. And that seems pretty consistent with what is argued in page 79. I mean, again, I don't know what you have to do, but it seems to be a stretch to me that you're saying they didn't bring that to attention, where all these cases, maybe not quite as robustly, but are laid out there. I mean, what do they got to do?
Well, Judge Quattlebaum, I agree. First off, I think you're right that page 79 and page 150 are essentially contain the same proposition. And so I understand that proposition to be, well, the Fourth Circuit said these cases were distinguishable, but there's no indication that the Fourth Circuit had rejected them in that, saying they're distinguishable is not saying that the Fourth Circuit had said that the claim could not proceed. I draw your attention to page 149 of the appendix, and on that page, ICON discusses, that's again in its trial brief, it discusses the Sixth Circuit decision in Crawford, and Crawford is based on the Michigan Court of Appeals case Samples that we cited in our brief. And so the point they're making there is the Sixth Circuit has affirmatively rejected this claim. And so from our perspective, it's not enough just to say, well, the Fourth Circuit has said there might be some other considerations underlying the Seventh and Eighth Circuit decision, but there's no express statement.
Yeah, I appreciate that. I mean, and I don't need to go over and over it. It's just, what Bishop or Raymond James, I think Judge Motz makes a good point. The case began kind of as a breach of fiduciary duty, and then because of the problems with that, the plaintiffs, tried to salvage it by arguing wrongful termination. And so our court addressed both the primary issue and said it was it was beyond the powers, and then considered the other alternative arguments, if you will, whether they're Hail Mary or otherwise, and said those don't apply. And as I read it, they say they don't apply if there's a contract that says it's at will, and which, was not the case in the Seventh and Eighth Circuits, but was the case there. And quite frankly, the contract as quoted in Raymond James isn't nearly as clear as the contract here. And so anyway, I'm having trouble, with the notion that this was not presented to the court. And quite frankly, I have a little trouble with the issue that you seem to say there's not a case on point, and I'm just maybe which would seem to preclude a novel theory forever being the subject of manifest disregard of the law. And maybe that's right. But here we got a general proposition that you're at will, and you're advocating an exception. And I grant you, North Carolina law has not raised that exception. But does that mean every exception that has not made its way to the appellate courts can't be considered manifest disregard? I asked a lot. That's probably about 5 questions. That's a little unfair, but
let me try to unpack that, Judge Quattlebaum, a little bit, and please let me know what I'm missing out on. I think
Sure.
We have to start with the court's case, Jones against Ansel, and in that case, the court expressly said there has to be controlling precedent that compels the contrary conclusion. And so I think that in the absence of a North Carolina case compelling the contrary conclusion, that is a North Carolina case along the lines of Crawford or Samples out of Michigan, I would agree that a novel theory can proceed in arbitration. Again, the point of arbitration is to allow the parties to effectively resolve their claims, and the court is not supposed to, even if the arbitrator is wrong about the way he interprets the law, the court's not supposed to second guess that determination. And so I think I am sympathetic to the idea that it's a novel interpretation of the law, but at the end of the day, the parties agreed to submit that to the arbitrator. I'd contrast that with a case, and I apologize for not knowing the name off the top of my head. I found it recently in my review, but Judge Thacker wrote a case in 2019 about a crop insurance arbitration. And so the contract in that case says you must consider the FDIC's position, and the arbitrator didn't. I think that type of disregard is manifest disregard of the law. The court in that case concluded that it was, but here it's just a difference of perspective. There is, as we point out in our briefs, there are exceptions to North Carolina's general employment at will doctrine. And so it was incumbent upon ICON in the arbitration proceeding to make the case that Bishop controlled, to make the case that there was a North Carolina case directly on point. And here
the panel decision is so sparse that is at least hard for me to say that they disregarded the law. Rule 12904, could either party have requested a written explanation of the decision so we would be better equipped at this point to determine whether the panel disregarded the law?
Judge Thacker, I think either party could have requested an explanation. In the FINRA arbitration manual that's in the record, I think it's in the 20s or the 30s, there's an explanation that if both parties request it, the arbitrator gets an honorarium. If one party requests it, they don't. There's no evidence in the record that either party requested it. And so,
right, I guess that's my point. Nobody requested it, so we don't really have, we would, well, at least one could argue we would be second guessing what the panel did at this point if we affirmed the vacator of the award, correct?
I think that's right. And, I'd highlight to the panel that it was ICON's burden to show manifest disregard. And on this unreasoned opinion, which ICON never requested an explanation for, I think it's exceedingly difficult to show that there was manifest disregard in this sparse opinion.
I think along the way, when we were discussing, what is it, the Raymond James case, it was said that the cases that it discussed, Argonne and Leung, that neither of those cases involved a state in which state law was employment at will doctrines. But actually, in Argonne, it did involve us. It did have a state that had employment at will doctrine, didn't it?
Judge Motz, just briefly, I see my time's about to expire.
You can answer the question.
You're right. Your reading of that is right. As Icon indicated before the panel, North Carolina is like 49 other states that's employment at will. And
right,
so,
but specifically, the court said it in Argonne, not a party.
Correct.
The court said it was that had an employment at will doctrine.
That's correct. That was a Kansas
Reached its
case.
decision notwithstanding state law employment at will doctrine.
That's correct, Your Honor.
Okay. Well, we'll hear from the other side, and then maybe we'll come back and tell us what you think. Okay, thank you.
Thank you.
Counsel? Lost my page. Yarborough?
Thank you, Judge. May it please the court. My name is Jonathan Yarborough, and I'm here on behalf of the Appellees Icon Advisors, Inc. and Icon Distributors, Inc. And of course, we are asking this court to affirm the award of the district court in the Western District, vacating the arbitration award in favor of Mr. Warfield. I want to make a couple of points about the standard of review. It's not for a court, although the standard of review is narrow, it's not for the court to simply rubber stamp arbitrator decisions, nor is it for the arbitrators to make public policy, which is what we would argue they did in this case. As Judge Mullen explained in his decision vacating the award, there were several ways, several grounds to look at vacating awards. And those grounds included where an arbitrator exceeded the powers and basically dispensed some form of industrial justice, or where the award doesn't draw its essence from contract interpretation. It's simply baseless, or again, manifest disregard.
You only argued manifest disregard, right?
Well,
that's your argument.
We argued, and the judge found manifest disregard, but the judge brought up those arguments as well, right, in his opinion. And frankly, any of the grounds would apply in this particular circumstance. But with respect to the manifest disregard, we would argue that the legal principle here was very clear and is not subject to
what is it? What
debate.
is the binding precedent requiring a contrary result?
Well, Your Honor, Judge Thacker, I would argue, frankly, that under these circumstances, the arbitrators didn't even have to go beyond the at-will employment doctrine here in North Carolina. The law is well settled.
Okay.
The law is well settled in North Carolina that
the employment agreements involving arbitration. That's the point, isn't it?
That's absolutely my point.
No, it's their point. It's what distinguishes this.
Well, my point
according
is,
to them, and what I'm asking you is there a North Carolina law that meets that involves an employment case? Because they say there's not.
Well,
and I thought you recognized there wasn't, and that's why we're talking about all these other cases.
If I may, Your Honor, Judge Motz and Judge Thacker, if I may backtrack just a second to answer your question. When you look at the offer letter expressly stated that nothing in the letter is construed as a guarantee of employment, and further stated that your employment with Icon Advisors, your being Mr. Warfield, is at will, and either party can terminate the relationship at any time without cause, with or without notice. That should have been a full stop right there.
Okay, but I'm not asking you about the contract. I'm asking you about North Carolina law. You told me North Carolina law was clear that you couldn't have an employment at will contract in these circumstances. So
well,
tell me what.
And that's what I was looking for.
Sorry.
Maybe
That's
I missed.
what I was looking for as well, a binding North Carolina case.
maybe I misspoke or was misheard, but my point was that North Carolina is clear that it is an at-will state. There is
And
no.
what is clear about that? So show me the case.
Well, we cited a variety of cases, Salter versus E&J Healthcare.
Right. And do any of them involve employment contracts?
No, because absent.
Well, they say that's the difference, you see. That's what I'm asking you to counter it with a case. I mean, because I would be perfectly amenable to listening to that. That's what we need.
Absent a contract of employment, which there wasn't one in this case, then employment is at will. And the arbitrator should have stopped at that point because it's clear at will employment is in play here. This is what the parties signed off on the offer letter that Mr. Warfield signed.
Do we know whether the panel interpreted this as a tort claim or a contract claim?
Well, if you look at what the plaintiff or Mr. Warfield suggested throughout the arbitration, it was approached as wrongful discharge. In fact, if you go and look at their amended statement of claim, they even hint at wrongful discharge in violation of public policy in North Carolina, which is actually an exception to public policy. And there is some hint about Mr. Warfield having a disability, but that is then completely abandoned. And it's only later on, in fact, this briefing where they say, oh, well, we're not talking tort, we're talking contract. But there's no contract here. It frankly begs the question of, well, what is the contract? Because the agreement that he signed expressly stated it was at will, it was terminable by either party at any time, and was not a contract. And in fact, Mr. Warfield.
Counsel,
yes, sir.
So I want to make sure I understand you're saying there is an offer letter that's signed. Are you saying that's not a contract?
No, you're right, Your Honor. That's not a contract. It's an offer letter that expressly disclaims that. It says your employment with Icon Advisors is at will, and either party can terminate the relationship at any time without cause, with or without notice. That's in the joint appendix at 2829 and also on page 78. And so that establishes the relationship between the parties as an at-will employment relationship, which either party can sever at any time. And in fact, Mr. Warfield, in his submissions to the court, makes reference to a proposed agreement where he was going to be promoted. And in fact, that proposed agreement is in the record. It's joint appendix 31 to 35. And if you look at that joint appendix, which has been submitted for your review, section 6.1 reemphasizes the at-will nature of his employment.
I'm sorry, I was asking about whether the arbitration panel, how do we know whether the arbitration panel interpreted this as a contract or a tort claim? I'm looking at JA 59, the award, and I don't see the words contract or tort in there anywhere.
JA 59?
Well, you point, maybe I'm looking at the wrong place. You just tell me how I know how the panel interpreted this so that I'm not second guessing what the panel did.
I would argue, Your Honor, that the panel interpreted this as a tort claim, wrongful discharge. This was what was submitted to the court. In fact, the words breach of contract are nowhere to be found in any of the FINRA filings that are before this court, nor were they before the arbitrators. And if Mr. Warfield is arguing that there's a contract, it begs the question of, well, what were the terms of that particular contract? And frankly, under North Carolina law, if there is an employment agreement, then you don't have a wrongful discharge.
I think Judge Qualibon was trying to get a question in. Have I misinterpreted your body language?
Well, I have one, but no, that's okay. No. Thanks, Judge Vermont. So here's kind of, I guess, the question I'm getting. I mean, as you know, the standard for us to review this is quite difficult. And, you know, if you look at the general requirements of disregarding the law, it seems to suggest the panel must have believed that this was an at-will relationship, that the Eighth and Seventh Circuit decisions didn't apply, and decided anyway to rule in his favor, almost as if so, which is a standard, quite frankly, that I don't know how you could meet. But my question, we seem to also have a line of cases that fall either under manifest disregard or under the essence of the contract that quite frankly don't really square with that general rule, but seem to say that if the contract is so clear, or if the relationship is so clear, we don't give the panel a chance to say it's an interpretation. Basically, it could not be a fathomable. Is that essence of the agreement, is that something that you briefed to us? So specifically, is that something that's before us on appeal? And second, how does that relate to the what I call the general way we would review an award, which is you have to show that it's basically arbitrator nullification, and so I hope that it makes sense.
I believe it did, Your Honor, and I would argue, yes, we did brief that.
Where would that be?
Looking at,
I looked for that.
Page 6 of our brief, and I apologize, I just have the brief in front of me, not the actual joint appendix section.
No, I'm talking about you wanting us to vacate it, right?
Yes, ma'am. Yes, ma'am.
Okay, so that's you have to be okay. And you say on page 6 you make this argument. Because I thought your argument was what we had talked about earlier, which is this manifest disregard. Now, tell me, by all means, if I'm wrong.
Well, what we did is we highlighted the two provisions. In fact, it's 10A4 that Judge Mullen relied upon. And Judge Mullen, in part, talked about the arbitrators exceeding their powers, or then so imperfectly executed it that a mutual final indefinite award upon the subject matter submitted was not made. Then we distinguish.
And then you have a following paragraph. You don't have to read to me your whole brief. What I want you to do is to talk to me about where in your brief you argue something other than manifest disregard, because right after you quote this, you start talking about manifest disregard. So
you're correct. We did go straight into manifest disregard from there. And regardless of whether the court looks at this from exceeding powers or dispensing their own brand of industrial justice or manifest disregard, I believe that the award should still be vacated because.
Okay, I hear what you're saying. But if we go back to what Judge Clawlon was just talking about, which is the standard here, I don't think in your argument in front of us, you've recognized which we have. We aren't the decision makers here. All we're doing is looking at the arbitration award and seeing whether we can disturb it. And what we've said many times, and most recently in 3S, which you didn't even cite, even though they cited it ad nauseum, appellant is required to show that the arbitrators were aware of the law, understood it correctly, found it applicable to the case before them, and yet chose to ignore it in propounding their decision. So where are we going to find evidence of that?
Well, I would submit that Judge Mullen did, and we've cited that.
We're not reviewing. We're reviewing the arbitrator's decision.
That is absolutely correct. You're reviewing the arbitrator's decision, and of course, we're moving to affirm Judge Mullen's award. And when you look at the education piece, because we have a duty to educate the arbitrators, and then they, of course,
to be sure the arbitrator understands what the correct law is.
That is correct. And when you go back and look at the record, Your Honor, when you look at the amendment,
believe me, I'm done.
Yes, ma'am. The answer to the amended statement of claim in the joint appendix, it was explained repeatedly that Mr. Warfield was an at-will employee. that only narrow exceptions applied, that the Argonne or Agron and the Liang decisions were not appropriate for these circumstances. Frankly, that the at-will nature should have ended the inquiry to begin with, and that the plaintiff, Mr. Warfield, cited no authority for his claim that Liang is somehow long established precedent, and it's certainly not precedent in North Carolina nor the Fourth Circuit. Yes, sir.
But counsel, I mean, I grant you North Carolina's at will, and I grant you this exception's not in North Carolina, and I grant you the offer letter says it's at will. So, I mean, I think that's all pretty fair and pretty clear. But he makes an argument in the arbitration proceeding that there's an exception to that, or should be an exception to that. And he cites these Seventh and Eighth Circuit cases. And don't we have to vacate it? Do we have to determine that the arbitration panel heard that argument, felt like it was wrong, and ruled with him anyway?
I think, if I understand Your Honor's question, you have to determine kind of a twofold step. One, was North Carolina the at-will just simply dispositive of this? And then two, does it fit into any of the exceptions that currently exist in North Carolina law? What the arbitrators did is they created out of thin air, as Icon said repeatedly during the arbitration hearing, they created out of thin air a new cause of action in North Carolina, wrongful termination without just cause. And in fact, I would argue that that was addressed quite squarely in the Raymond James Bishop case. Judge Motz asked earlier about whether that was a wrongful discharge case. And if you look at the initial claims that were brought, the answer is yes. Wrongful discharge.
But ultimately, it's decided on the basis of this ethical problem, right?
Ultimately, it was decided on the basis of an ethical issue, which was outside the scope of their performance, and then therefore outside the NSDA piece, which is the precursor of FINRA. But one interesting
disregard case.
But one interesting piece that I think is applicable to this particular case is an exchange that took place with the court when it held a hearing on the motion to vacate. And during that particular hearing, and it's noted in the Raymond James decision, at the hearing for the motion to vacate, the counsel for the claimants was asked what the actionable conduct was. And their reply was wrongful termination. And then it begged the question from the court of, well, how can termination be wrongful under the terms of this agreement? It's an at-will agreement.
So you claim, do you not, that Raymond James is dispositive here?
I would argue it is.
Well, how could a Fourth Circuit case be dispositive of North Carolina law?
Well,
that would be a new one on the people of North Carolina.
I grant you that, but the argument that has been made here is twofold, that we didn't educate them on the law. We educated them on North Carolina law, clearly, which is at will, at will, at will. No exceptions were brought here. This was not a breach of contract claim. There's no public policy at issue, despite it having been hinted at in the initial statement of claim.
Okay, but you heard Judge Quattlebaum's question to you just a few minutes ago. We understand that you've made these general arguments, and that you made the general argument that North Carolina law does not allow at will. But you don't have anything that counters, that tells us that the arbitrator looked at these cases and decided that they were wrong. Those are those two out-of-circuit cases, and still went ahead.
It's not a reasoned decision from the arbitrator. So there's nothing to look at beyond the pages that they did issue.
Did you ask for a reasoned decision? Did you ask for make a motion? I think that my colleague asked your opponent about that, and he said that nobody had asked for a fuller explanation.
I was not counsel at the arbitration, Your Honor.
It doesn't matter. I was years ago in front of Judge Winter, and somebody
Right.
said that. Go get the counsel is what he said.
Right.
That's no excuse, you know. it's your
I was
place
going
now.
to finish by saying my understanding, though, is that for a reasoned decision, it has to be asked for jointly by the parties. That's my understanding of the FINRA rule.
Well, and I think he said that, but did you ask them if they would do that?
I apologize to the court. I do not know the answer to that question. I've been through the transcript, but I don't see that either side asked for a reason here.
Counsel, in that situation, I mean, we have the award, whatever it is, and how do we deal with that? If our standard is we have to be able to conclude that the panel, fault the Seventh and Eighth Circuit cases did not allow for this type of a claim, but allowed the claim to go forward anyway, and we have a decision that's not reasoned, what do we do with that? I mean, let's assume they did decide that. If it's not apparent from the panel, are we supposed to, infer it? I don't know how we would do that.
Well, Your Honor, the position I would take is this, that the parties agreed that this was an at-will employment situation. And there's agreement between the parties on the exceptions to at-will employment under North Carolina law. And none of those exceptions apply. And so
North Carolina had this exact situation where they have an employment agreement and said there's no at-will employment. So that's your problem. You keep talking about North Carolina law. And we don't have a North Carolina case.
Your Honor, with all due respect, I would suggest that if that claim was brought in state court, it would probably be met with a Rule 11 motion, because the FINRA piece is not something that these parties negotiated. It was imposed upon them. What the parties negotiated with respect to the employment was, here's your pay, and it's going to be at-will employment. And Mr. Warfield signed off on that. This is, in effect, a glorified form selection clause that's been imposed by FINRA. And
see, your time has expired. I just want to be sure that you understand that this manifest disregard standard and our review of arbitration awards is more deferential than anything I've ever seen. I've had my law clerk go back and look at manifest disregard cases. And do you know how many published opinions there are in which we have found that there was manifest disregard? One. Do you know how many we found there was not manifest disregard? Many.
And I understand.
It's just an incredible standard. And I think you keep trying to argue the merits to us as if we're some state court.
I appreciate your position, Your Honor. I would suggest this.
Not my position. Do you have contrary facts?
And I'm not trying to argue the facts, Your Honor. I'm taking the position that at-will employment was agreed upon by the parties. FINRA arbitration was not something that the parties agreed on. And the doctrine of at-will employment is applicable. The parties agree to that. There's no exception under North Carolina law. Therefore, the inquiry should have ended there. That's our position. And even if you look at the Raymond James Bishop case, it supports our position, and we would respectfully ask this court to affirm Judge Mullen's order vacating the arbitration agreement, or vacating the arbitration award, rather.
Thank you. Does anybody have further questions?
No.
Thank you very much.
Thank you.
Thank you, Judge Motz. I'll address 3 points on rebuttal. The first point that I want to address is your concern in particular, or the point you raised about the Bishop case. That case was decided under Florida law. So I think the argument about Bishop is maybe we're assuming too much. The case is a Fourth Circuit case, but it's a case about a contract that's interpreted under Florida law. That takes us back to this point that there is no case addressing North Carolina law on this point. If you look at the Sixth Circuit case in Crawford that Icon cited at page 149 of the appendix, That's addressing a Michigan case that squarely rejected Agron and Lang, but there is no comparable North Carolina case. Turning to your point, Judge Quattlebaum, about well, how do we know? What should we know? What the panel decided? Your Honor, this court has many cases that say that the burden is on the movement to demonstrate manifest disregard, and it's a heavy burden. ICON, I think, has conceded that there was no request for a reasoned decision. There is not a reasoned decision. There are only portions of the hearing transcript in the record. Based on the record that was before the district court, it was error to prove ICON's case for it by doing exactly what ICON is asking this court to do and revisit the merits of Mr. Warfield's claim.
Could I stop you there? And I think that's right. It is the party seeking to vacate's burden. Yeah, the part of the law that seems to be a wrinkle for me is the U.S. Postal Service case and to some extent the Raymond James case that talk about this notion that when a contract is involved that is crystal clear and not capable of an interpretation like the one you apparently advanced, that we view, maybe even without the evidence that you normally have, that the award just fails to reflect the essence of the agreement just on the basis of the text of the contract. And that's what it looks, that's how the way I read a sliver of cases from the Fourth Circuit. So I have a couple of questions on that. Number one, do you have a position over whether that issue has been presented to us by the parties? And number two, if it has, or if we elect to consider it separately, what's your response to those cases?
As far as I'll address those in order. No, that position's not been presented by the parties. As my friend on the other side said, Judge Mullen listed the reasons for vacating an award in 10A4, but focused on manifest disregard. We briefed manifest disregard and ICON responded in kind. There's no alternative basis for affirmance in ICON's brief. So it is our position that ICON has waived that argument. Even if the court were to elect to forego that waiver, I think here it would be our position that the contract is ambiguous, and I want to help the court understand that a little bit, because I know that's not what the agreement that's at 22 and 23 of the appendix says. The agreement says one thing, but if we look at page 180 and 181 of the record, that's when Mr. Warfield signs this arbitration agreement. That's his Form U4, which is consent to agreement to arbitrate. That's dated in May of 2017, which is after his April 2017 agreement. And so we've got a subsequent change where he gives up valuable rights, ICON gives up valuable rights, and they agree under the rules of FINRA to arbitrate all of the disputes that arise among them. Based on our reading of Agron and Lang, the 8th and the 7th Circuit case respectively, that act is an exception to the at-will employment, even though the contract says it's at will. By agreeing to arbitrate at a later date, the parties have agreed that his termination must be for cause. And so I hope that answers your questions, Judge Quattlebaum. We think they've waived it, and we think that there is enough in the record based on Agron and Lang for that the arbitrator could have, I see my time's expired. May I briefly conclude?
Yes.
There's enough in the record based on Agron and Lang to support our interpretation of the contract. And so with that, we would ask that this court reverse the judgment of the district court and reinstate the arbitration award. Thank you.
Do we have further questions? Anybody? Thank you very much. You will proceed directly to our next case, number 2197, claim. Okay, I've called the case. We're happy to hear from Mr. Bowman in number 2197.
Thank you, Your Honor. May it please the court. The district court here did three things. One, it granted policeman Austin McLean qualified immunity against Jeremiah Henderson's 1983 malicious prosecution claim on the grounds that there was no constitutional violation. Secondly, it held that Henderson did not plead a 1983 retaliatory prosecution claim. And thirdly, the court granted McLean qualified immunity against Henderson's 1983 excessive force claim on the grounds that there was no constitutional violation. I'd like to begin with Henderson's claim that the district court erroneously held that Henderson did not plead a 1983 retaliatory prosecution claim. That's the second issue presented in our brief. I'll then discuss the malicious prosecution claim and finally the excessive force claim. The district court erroneously held that count 2 of Henderson's complaint did not adequately plead a retaliatory prosecution claim. One reason given by the district court was that there were no specific factual allegations relating to a retaliatory prosecution claim. That was simply false. Paragraphs 9 and 10 on Joint Appendix page 12 of the amended complaint clearly state a retaliatory prosecution claim. And paragraph 21 in count 2 of Henderson's amended complaint specifically alleged that McLean, quote, obtained through false and malicious swearing to the magistrate a warrant of arrest against Henderson so that he could retaliate against Henderson for his complaint against him, end quote. The other reason given by the district court for dismissing the retaliatory prosecution claim was that Henderson did not plead he was retaliated against because he was engaged in protective speech, or that retaliatory animus was the but-for cause for the arrest and prosecution. But that's also false. The portions of the complaint I just quoted constituted an adequate claim that McLean initiated the prosecution because Henderson made a complaint about him to the police department, and that was the only reason why he initiated the prosecution. And by 2018, the right to be free from prosecution and retaliation for protected speech was clearly established in Hartman versus Moore, a Supreme Court case.
So counsel, if I could interrupt you on this point, you're looking at the complaint and the district court's order, and that's certainly a fair thing to do. But in the complaint, the original complaint, and what turns out to be the operative complaint, I mean, you have 2 counts, and retaliatory prosecution's not one of them. And you later moved to amend to add a count to make it clear you were seeking to recover under that as opposed to just alleging some facts. And then you withdrew that, and that may be a perfectly legitimate thing to do. Please don't take this question as some sort of accusation that you did something wrong. But when it's withdrawn, when the complaint that actually frames that as a cause of action is withdrawn in a counseled case like this, I mean, is the district court really wrong to say? I mean, that seems to cut against your argument pretty strongly.
I appreciate the question. 2 things in response. First of all, count 2, the way that it's pleaded, the only thing it's missing is a label that says retaliatory prosecution. So in response to the first part of what you said, if I had included the word retaliatory and included those 2 words with malicious prosecution, apparently it would have been fine. Okay, but secondly, the point about the amendment, there were some complicating factors here, and the district court judge, although this was his first day on the job, but I mean, he is from Roanoke and is familiar with the circumstances here. Okay, one of those circumstances was Judge Glenn Conrad, who was assigned the case, was very ill. And so this case sat for a year with my motion to amend pending with no action. And only as the state court statute of limitations for filing this case in state court approached did I withdraw the motion to amend, because if I didn't do that and file it in state court, I would have run into the statute of limitations in state court, and the state court would have said, well, you have this pending in federal court. Okay, so that's the logic behind why I withdrew it. Also, COVID was going on. So in fairness to Judge Conrad, it wasn't just that Judge Conrad was ill, but Judge Conrad was ill and COVID was going on, the very first part of COVID, when we were all very afraid of COVID, throughout that entire period. So that's why, even though this was a counseled case, and I made a, hopefully a professional decision, that was the basis for the decision. And the district judge knew that. So I don't think that's a good enough reason for him to have dismissed it.
And I appreciate that, and it may not be really ultimately what we should be looking at, but am I correct then, if I may ask, that you pursued a retaliatory prosecution claim in state court?
Yes, sir, that is correct. And what happened in state court was that by the time this issue, that we had a hearing in state court, the district judge in federal court had ruled that McLean had probable cause to initiate the prosecution because he had the arrest warrant from the magistrate. And so applying Nieves versus Bartlett, which is the Supreme Court, the latest Supreme Court case on retaliatory prosecution, the logic of the state court was that since McLean had probable cause to initiate the prosecution, the issue of whether there was retaliatory animus was irrelevant. And so the district court's ruling on probable cause precluded the state court from determining the retaliatory prosecution claim. Okay, so so that's what the state court ruled. Now, the state court did defer entering a final judgment dismissing the state court claim until this court rules. Okay, so the state court case is kind of in hang fire over this probable cause determination by the district court.
I appreciate that. Thank you.
Yes, sir. As I was saying,
can you get to the probable cause determination by the district court, the qualified immunity issue?
Yes, ma'am. The issue of probable cause on both malicious prosecution and retaliatory prosecution, the issue there is what the policeman knew on October 19th. Now, the district court focused on what he knew on October 15th, or what he saw on October 15th, when the incident at Walmart occurred. But the policeman didn't arrest him that day. The policeman didn't do anything to initiate a prosecution until 4 days later. And in that 4 days, that's when Henderson, my client, went to the police department and filed a citizen's complaint. The police sergeant told McLean to reinvestigate the case and to, in as many words, initiate the prosecution of Henderson. And the policeman did that. So by October 19th, this citizen's complaint had occurred, and the policeman had investigated it. And by October 19th, the policeman had talked to Shelton, the alleged victim, twice. And in those both instances, Shelton said he did not want to press charges. And he said that Henderson only slightly touched him. And he didn't say anything about feeling fear of bodily harm. And under Virginia law, I'm sorry, Your Honor, go ahead.
So I think you were going to answer my question. Does battery under Virginia law require fear?
Yes, ma'am. Battery under Virginia law and battery involves a touching, but the touching has to involve an offer of bodily harm. And that part was completely missing from the probable cause here. Shelton had said he did not fear bodily harm, that Henderson just lightly touched him. And you can look at the video.
I see the fear part in the assault, the crime of assault in Virginia, but not battery.
Yes, ma'am.
Battery consists of conduct done in a rude, insolent, or angry manner. Maybe you can point me to.
Yes, one of this court's cases, Fialdini versus Coate, which is cited in my brief. It's at 594 Fed Appendix 113, pages 121 through 220. well, I've got my pages messed up, maybe. It's Fed Appendix 113, 121 through 122. And what this court said there is that the assault must actually create a reasonable fear or apprehension of bodily harm in the victim. Okay, if the touching occurs, then the touching must be in a rude, insolent, or angry manner. And this court said that in the case of Park versus Shiflett at 250 F 3rd 843.
Well, do you dispute that appellant did make contact with the person in the Walmart store, physical contact?
My client's testimony would be that he doesn't think that he actually touched him. There's a video which the court can look at. Even if he touched him, it was very light. It was very slight. It wasn't legally a battery. And it wasn't legally a battery because it wasn't done in a rude, insolent, or angry manner. And it didn't.
He wasn't angry?
No, sir.
The appellant was not angry, you're saying?
No, Your Honor, I'm not talking. It wasn't done in a rude, insolent, or angry manner. It was a reach out to someone to try to get his attention.
I think that mischaracterizes because, we have the tape. I think your client was angry and perhaps justifiably so. I would be angry. But
yes,
that doesn't square with what you're saying about this argument about what is a battery.
Well, right. I don't think that it offered bodily harm. I mean, that's not the way I see it. It doesn't offer bodily harm. I think different people can view it in different ways. Okay, but it wasn't a battery. Now, in terms of the video,
than a Fourth Circuit case, which apparently is unpublished interpreting Virginia law, is a Virginia Court of Appeals case from 2010, which says it's not necessary that the touching result in injury to the victim's corporeal person. It is sufficient if it does injury to the victim's mind or feelings.
Yes, ma'am, that's correct. And I just tried a case on that where that was an important issue in the case. And in the way that applies to this case is that McLean had no information from Shelton by October 19th. And he had talked to Shelton twice at that point, that he felt that mental apprehension or insult or that mental injury that would meet the part of battery that you're talking about in that 2010 Virginia.
You think that the person to whom the battery was assertedly given, if he says, oh no, it's no problem, that eliminates the fact that a battery took place? Is that what you're saying? I think that is what you're saying. Maybe you're right.
Yes, ma'am. I mean, I think that is certainly an important factor, and I think that is what I'm saying. But I'm also saying that there were additional factors here in that McLean talked to this man twice. He talked to him on the day the incident occurred, and the man said it wasn't a big deal. Okay, then his sergeant told him to go reinvestigate and, in so many words, initiate a prosecution of Henderson for the assault and battery. The policeman went back 4 days later, and Shelton said the same thing. It just wasn't a big deal. It was a light touch. He said, I don't want to waste the court's time with this.
Well, but of course, I thought that the touching, whether the touching was a battery, depends on the intent of the actor. And we don't get intent from just what your client would say. We get intent from how this would appear to other people.
Okay, but what was he intending to do? He may have been, assuming he was angry. What was he intending to do? Was he intending to grab him and pull him to the ground? Was he intending to hit him? And maybe conversation, you could call it an argument, but to continue that rather than to injure him because he wanted to have his say. Henderson wanted to have his say, and his say was, you can't stop me for this reason, and you can't throw me out of here for this reason because he didn't do anything. And so that simply didn't constitute a battery. And McLean knew that by October 19th. 4 days later, he knew that. I think any fair-minded person would understand that if he'd thought there'd been a battery, he would have charged him on October 15th, that by October 19th, the only reason why he was prosecuting him was because he had this retaliatory animus. and the probable cause should be mitigated by my time's up, by his failure to act prior to that.
Thank you. Well,
Yes,
I think you have some rebuttal time.
Yes, ma'am.
Counsel, we're ready for you.
Thank you, Your Honor. May it please the court, my name is Tim Spencer. I'm from the City Attorney's Office for the City of Roanoke, and I am representing Officer Austin McLean in this matter. Your Honor, I'm going to pick up where we've been discussing on this matter. The district court did find that it was not pled. There are only 2 counts listed in the complaint. There are some facts which somewhat indicate, but we also need to do is we need to look at the timeline. This occurred in October 2018. This court, in the case of Peg versus, it's the Peg case versus Herman, where is that? I'm sorry, y'all. Just let me get to it real quickly. Peg versus Hernberger. This issue came up, and in that particular case, this court quoted the Supreme Court. It said, the Supreme Court has never recognized the First Amendment right to be free from a retaliatory arrest that is supported by probable cause. That was citing to Reichley versus Howards. The court then went so far as said, since the Reichley decision, no such right has been recognized, so the Reichley principle is fully controlling here. Now, the Neves case doesn't occur until 2019. So how can it be clearly established that Officer McLean knew or should have known that even with probable cause, there could be a very narrow but-for case exception to a retaliatory prosecution claim?
So, counsel, can I want to make sure I'm understanding your argument. Are you saying that the probable cause issue that applies to the false arrests and the malicious prosecution counts that are plainly pled, that also applies to the retaliatory prosecution case claim if we were to find one was pled?
Yes, I do believe so, Your Honor. From a qualified immunity standpoint, was it clearly established that such a cause of action existed? I would suggest that no. If you look at Supreme Court rulings in Neves, they even indicate that, hey, we've ignored this issue twice before because 2 cases where first case was found on different grounds, and the second case was an obscure one where we found municipal retaliation. So the first time that they looked at whether or not with probable cause a case could go forward for retaliatory prosecution or arrest was the Neves case, which was decided after this case, after October 2018.
So aren't there 2 issues that come from that? One, prior to Neves, there's not a clearly established right. And 2, even after it, probable cause, if it was objectively reasonable to believe it existed, would provide a qualified immunity defense. Is that right?
I believe it would, Your Honor. The Supreme Court gave a very narrow but-for situation. If you remember in Neves, they gave an example of if someone was an outspoken opponent to the police department who then got arrested for jaywalking, when no one gets arrested for jaywalking, that then could constitute where there was probable cause, but a claim for retaliatory prosecution or arrest might apply. I would argue that we don't have those situations here, Your Honor.
So before we get there, your colleague first argued that the district court was, made a mistake or erred in saying there was not a cause of action pled in the first place. And, and there's I think a interesting argument that strikes me is that how does he reach that conclusion about that claim where he didn't reach it for excessive force? Part of me is like, okay, there's two claims pled. It'd be reasonable to say I'm sticking with the two claims pled despite a stray word here or there. But once he kind of goes beyond the two claims pled, I think I got that backwards, two claims pled, and recognizes an excessive force, what's the basis for not doing it with retaliatory prosecution? I know that's irrelevant to the arguments you just made on the merits, but about whether it's properly pled.
Your Honor, I'm about to do two things very dangerous. First of all, try to get in the head of the district court judge who made the ruling. But my belief is, based on what I've read and what I heard him state, is that he just didn't believe that the sufficient facts were pled to put a party on notice, to get over the Twombly-Iqbal hurdle, if you will, to satisfy that. That he did not believe that it got to that level where it would put the party on notice. And in fact, it was not on notice, or else I would have pled more definitively the qualified immunity issue. So I think that's where he came down on that. But the other dangerous thing I'm about to do is, I think that given where the court came in Nevis, that there is a lack of guidance of where there might be a claim of retaliatory prosecution when we have, as we do here, probable cause. So for all these reasons, I think that really the default situation is that Officer McLean is entitled to, or is protected, I should say, by qualified immunity. Also, I'd like to clean up the record with one other thing. On October 15th, one of the reasons why the sergeant directed Officer McLean to go back and re-interview people is he did not speak with Mr. Shelton about the details. If you look at the video, he sent out Ms. Peterson to ask if they wanted the charges. And the only reason that the sergeant said, go back and talk to the people yourself, is not to rely on a third party as to whether these individuals wish to press charges. Now, the other thing that he learned by the 19th is Mr. Shelton told him that his arm had been grabbed and that he wanted to press charges. So for those reasons, he moved forward. I believe that the probable cause defense also applies and allows qualified immunity for the malicious prosecution claim. There, the courts have been very clear that when probable cause exists, that you will indeed have a defense to malicious prosecution case. And in this instance, the courts have been really, the fact that Officer McLean went to a magistrate and had an independent third party determine whether an arrest warrant would be issued goes towards Officer McLean's. It makes it objectively reasonable, his actions. So when we look at everything, the district court was 100% correct in finding that Officer McLean was protected by qualified immunity for his claim of malicious prosecution. Now, the other part of the case, that it's all on video, it's all for everyone to see, is the district court, I believe, properly on the claim for excessive force. went through the proper standards in Graham and went through and looked at the 3 points: the severity of the crime at issue, battery, whether the suspect posed an immediate threat to the safety of officers or others in the area. He had already demonstrated that he is willing to reach out. Tensions were high, I believe, as Judge Mott said, looked like he was angry. Therefore, it was justified for Officer McLean to attempt to detain Mr. Henderson by putting him in handcuffs. What happened when he tried to do such? Mr. Henderson resisted. Now, again, I go to the Peg case, where we can go through several things in applying this reasonableness. And again, officers have to make split-second decisions. But one of the things I like to look at the Peg decision, the plaintiff or the appellant in this case has not shown any case that clearly demonstrates that Officer McLean violated a clearly established standard in the amount of force that he used in this instance. However, I found a case from 2017, Peg versus Hernberger case, that 2017, this court found similar situations. Now, I'm going to go through how they're the same and how they're different. How they're the same, both officers were attempting to place a criminal suspect in handcuffs. In both instances, law enforcement officers instructed the suspect, put your hands behind your back. In both instances, criminal suspects refused to comply with the law enforcement officer. In both instances, the suspects actively resisted being handcuffed. In both instances, both defendants asked, why is this happening? Why are you doing this? What are you doing? In both instances, the law enforcement officers then grabbed the criminal suspect in an effort to place him in handcuffs and used a police maneuver with Officer McLean. He tweaked the wrist in a manner that it required or helped encourage Mr. Henderson to comply, put him in handcuffs, and then left him in a stand position, no further violence. Same thing happened with Trooper Hernberg, except he took the individual to ground. So this happened after both officers had witnessed a violation of the law in person. So how are they different? And this is very important because this goes again to the Graham factors. So we have, what did they observe? What crime did they observe? Trooper Hernberger is dealing with an expired license, an expired inspection sticker, excuse me. So it's down here. Whereas Officer McLean is dealing with a battery. I think it's a more dangerous situation that Officer McLean's dealing with.
When you say battery, it does sound more dangerous, but when you look at the actual facts here, it doesn't feel more dangerous. So I don't know that that's really helpful to you.
Well, again, as we talked about earlier, the definition of battery that's been recognized in Virginia, this establishes a battery.
No, I understand the definition of battery, and the video certainly indicates that there was a battery, but to make this, what happened at Walmart, into, the crime of the century is, it was not.
I hopefully am not doing that, Your Honor, but I do think it's a little more severe than an expired inspection sticker.
Yeah.
I don't know that, yes, you're right, but I don't know where all this is going.
The only other part is, the other difference is, I'm sorry, Your Honor.
All this is about is whether this is excessive force, right?
Correct.
Your argument that you've just been giving us.
Yes. And in Peg case, Trooper Hernberger took the suspect to ground, put him in handcuffs. There, this court found qualified immunity for that use of force. Here, I believe that Officer McLean used less force than in the Peg versus Herrenberger case. And that's the other difference. And in doing such, I believe that the district court was appropriate in finding that he's protected by qualified immunity, or he even went further and said, find that there was no constitutional violation in the use of force. So for those reasons, we believe that the district court was appropriate because there's probable cause, because Officer McLean went to a magistrate and obtained a warrant, that there is the protections of probable cause for malicious prosecution. Also believe when you look at the totality of the circumstances and you evaluate the claim for retaliatory prosecution or arrest, that again, Officer McLean is protected by qualified immunity because there is the presence of probable cause. And in 2018, the law was that was an absolute defense. This court again in the Peg case found that. And finally, when we look at the use of force, and all this is captured on film, when we look at that, we believe it's objectionably reasonable that the force used by Officer McLean was that which was necessary to contain Mr. Henderson. Remember that he satisfies all three of the Graham matters, and that he was actively resisting at the time.
I think we understand your argument.
And that's our case, Your Honor. Thank you. We ask
Thank you very much.
affirm the district court's ruling.
Mr. Bowman, do you have a rebuttal?
Yes, Your Honor. I think I'd like to begin with just pointing out that, we can all look at the video. The general district court judge who tried the assault and battery case found that Henderson was not guilty of assault and battery. Just throw that out there. Now, I'd like to return to where Mr.
A probable cause standard is different than.
Yes, ma'am.
The
It is.
standard at trial.
Right. An unusual aspect of this, maybe it's not unusual in this day and age, but an aspect of this case is that probable cause and then later determinations of guilt and innocence kind of merge together, though, when we can actually see what the policeman saw. That's the only point that I'm making. But to begin where Mr. Spencer began, Mr. Spencer argues that on the timeline that it was not clearly established in 2018 that a person has a right to not be prosecuted in retaliation. That's not true. The Supreme Court's Hartman versus Moore case in 2006 recognized the right to not be prosecuted in retaliation for protected speech. Now, there's a line of cases after that, a short line of cases, and Nieves is as after that. Our position is that Judge Quattlebaum is correct, that under the law that the Supreme Court's articulated so far, that frankly, probable cause does defeat a retaliatory prosecution claim.
So it goes back to whether there was probable cause.
Right, it does. And why the district judge didn't address that, that's a good question. I don't know that either. But this probable cause defense to retaliatory prosecution is qualified by the Supreme Court in the Nieves case. And in the Nieves case, it said that if the person wouldn't have been prosecuted anyway, then he can proceed on a claim for retaliatory prosecution. So our position is that he wasn't going to be prosecuted but for this retaliation. We can prove that. And so this fits within that qualification to the Nieves case recognized. And then further, even if the court finds that it's constrained by what the Supreme Court said in Hartman and Nieves, okay, that's wrong. That should not be the law. And so I'd like to preserve that, because the policeman would simply be able to immunize themselves from retaliatory prosecutions by once somebody is complained about them, going to the magistrate saying the person committed a crime, and then once they have the arrest warrant from the magistrate, be immunized from retaliatory prosecution. Okay, that's what Judge Gorsuch said in the Nieves case, and that's perfectly correct. So I want to preserve that argument. So
this argument is all about retaliatory action, right?
yes, ma'am. Yes,
And I thought in response to Judge Quattlebaum's questions early on, you acknowledged that you hadn't pled that. Is that right? I missed
no, Your Honor. I'm saying that based on the vibe that I got from Mr. Spencer, that I thought that I ought to improve the pleading of it by putting the word retaliatory in the complaint. But my position is that the original complaint that we filed perfectly adequately pleaded retaliatory prosecution under the Twombly-Iqbal standard. And Mr. Spencer's argument that he didn't have notice of it, that's belied by the fact that that issue was fully briefed on summary judgment for the district court by the city as well as by us. We talked about Hartman, we talked about Reichel, which is the case he cites here today. We talked about Nieves. So they were on notice that there was a retaliatory prosecution claim.
When did you amend the complaint?
I was never allowed to, we never amended.
So you never amended the complaint. So
That's
it's not
correct.
pled.
Right. Well, I'm saying that the amended.
You say it's incorporated in the original.
Yes, ma'am. It's subsumed in what we pled. Right now, Mr. Spencer argues that on October 15th, the day of the incident, that McLean did not talk to Shelton. Okay, that is a profound factual dispute in this case. Shelton said in his deposition that he did talk to McLean. McLean denied it. But that's just a plain factual dispute. On summary judgment, that has to be resolved in Mr. Henderson's favor. I'll have to rely, because I'm running out of time. I think I maybe have run out of time. No, not quite. I'll have to rely on my brief on the excessive force claim and on the malicious prosecution claim to a large extent. But I really want to emphasize, what I've really wanted to emphasize here today is that we did adequately plead retaliatory prosecution, and the law should not be applied in Mr. Henderson's case, that McLean could immunize himself from the retaliatory prosecution claim when clearly he did retaliatorily prosecute Mr. Henderson because he went to the magistrate after the fact.
Thank you very much.
Yes,
I don't think we have further questions. Okay. Thank you very much. We will go on to our next case, which this is number 2386. Do we want to take a break?
No,
Okay. Sorry.
I'm good.
All good. So, Mr. Bowman?
Yep,
Ready?
yes, Your Honor.
Okay.
Just have to switch gears. Okay. May it please the court. In this case, I will first address Mr. Henderson's claim that he has a liberty interest in going to private property unless barred by someone with an interest in the property. Specifically, the private property in question is the Walmart store at 4807 Valley View Boulevard here in Roanoke. The major premise of the district court's decision that Henderson does not have a liberty interest is invalid because it's set up and then knocked down a straw man. That straw man is that Henderson claimed that his liberty is that the district court said that Henderson claimed his liberty interest arose solely from the trespass bar statutes, that the source of his liberty interest was the trespass bar statutes and not the Constitution. The district court knocked down that straw man by ruling that the trespass bar statutes did not create a liberty interest and that Henderson therefore failed to state a claim. This was erroneous because the district court misanalyzed the source of the federal liberty interest that Henderson seeks to indicate, which is the freedom of movement that was deeply rooted in American and Anglo-Saxon law and existed as a liberty at the time the Constitution of the 14th
So what is your binding authority that invitees have a liberty interest to remain on private property per the Constitution?
Well, people, when asked like that, I think I have to break it down in two parts. people have freedom of movement to go to public places. Okay, the binding authority on that is Chicago versus Morales and Kent versus Dulles. Those are Supreme Court cases. People have a right to go to public places. Public places can be private property. That's
So,
the authority for that is
so
Rogers
Walmart
versus.
is a public place, a
Yes,
public
ma'am.
property.
Yes, ma'am.
Uh-huh.
And so Henderson has a right of movement to go there. Now, of course, he can be prohibited from going there by someone lawfully in charge of the property. And that,
Isn't that what
Is-
they did?
no, ma'am. No, Your Honor, that is not what they did. Now, this case was dismissed at the 12B6 level. So we're looking at what the complaint alleges. But what happened here was that Walmart has set up, not surprisingly, a business trust to own the real estate. Virginia passed a statute that allows localities to create a trespass bar ordinance that allows the owners, well, the Virginia statute allows a person in charge of the property, and it describes various things, including a tenant, to appoint the police as its agent to bar people from returning to the property, to issue a trespass bar. Okay, Roanoke, the city of Roanoke, they specifically require the owner of the real property to be the appointer of the trespass bar, to appoint the police as the trespass bar authority.
Because there's a different Walmart entity. That's your whole case, right?
That's right. Well, it's not the whole, I mean, I disagree it's the whole case, but that
There's
is
a
the
difference
point that we
between
are making.
Walmart and what? A difference between
Okay,
Walmart
there's a
and
difference
what?
between Walmart Stores Incorporated, which is the tenant operator of the store, and the
Oh.
Walmart Business Trust, which is the owner of the real property. And under the Roanoke ordinance, only the Walmart Business Trust is, as the owner of the real property, has the authority to appoint the police department as the trespass bar authority. And they never did that.
Oh, but they could do that tomorrow if they wanted.
But they didn't. They have not yet
But
done
they
it as far
could.
as- They could, yes, Your Honor. Yes, of course. Yes, they could.
Maybe they will.
Surprisingly, this litigation's gone on for a while, and I don't think they've done it yet. So I'm not sure. I can't read Walmart's mind, but they have not done it yet. Okay, so as far as the authority that he has, your question was the authority that Henderson has to go to the private property. He has a right to free movement unless he's barred by the person legally authorized to bar him. No one has barred him other than the policeman, and the policeman didn't have the authority to bar him. Okay, and that liberty interest to go to Walmart, that arises from the federal Constitution because it pre-existed the federal Constitution and the 14th Amendment.
So you're
So,
not arguing,
counsel-
this- sorry.
Go ahead, Judge Motch.
No, go ahead.
So, it may be the same, maybe we're going to ask about the same thing. So this is a procedural due process claim that we're talking about. Is that fair?
Yes, Your Honor.
Okay. And you're arguing, and I grant you argued in your briefs that, there is this freedom to move, freedom of movement, issue. But doesn't, in your, as you also point out, we're at the 12B6 stage, and as I read the complaint, all the allegations about liberty interest related to these statutes. And maybe I missed some of it. If you would just point me to the JA number where you pled this general constitutional freedom of movement as compared to liberty interest based upon the statutes.
In JA 74.
Okay, hold on just a second, please. Okay.
Okay, JA
We're in
74.
JA 70.
count 3 of the complaint.
Says procedural due process requirements of VA Code 50.
Right.
I mean, isn't it referring to the statute?
No, paragraph 58, Your Honor. Page 74.
Right.
Okay. Yes, and I mean, it does refer to the statute, but the statute is a better way to have pleaded this case, admittedly. Okay, and I will admit this, but we're at the 12B6 stage. Would have been, in retrospect, for me to simply say that Henderson had a liberty interest in freedom of movement, which included the right to go to Walmart unless barred by someone who had authority over the property. To just say that. Okay, then the city would have defended that claim by saying it had the right to bar him under the trespass bar statutes, which is what it is saying. Okay, and then Henderson would have replied that the city didn't follow the statute and he has no recourse to vindicate his constitutional right to movement because there's no way to appeal an action like this by the city. Okay,
But
that would
we're, and maybe so, but I mean, you can, I think, the law allows you to bring a procedural due process claim based upon the Constitution. I think that, is certainly the case. And you have based on constitutional liberty interest. And you also there's case law to support the ability to bring a procedural due process claim for liberty interest, deprivation of liberty interest that derive from statutes. But there's some requirements when you do it the second way. And I mean, it just, as I read the complaint, because I tried to do that to make sure I knew what we were talking about, the complaint seemed to refer that the source of your liberty interest was the Virginia Code and the Roanoke City Code and ordinance enacted pursuant to it. And then I realized in your briefs you argued the constitutional things. I don't think you've waived that to us, but I think we go back to the complaint, and I'm trying to. It sounds like you want us now to say I consider the complaint as if it was pled from a constitutional liberty interest, when what you pled was a statutory liberty interest.
Your Honor, I'll accept that's a perfectly fair criticism of what I have done and am doing. Okay, but the first point that you made is that a way to do this would be a person, not what I'm trying to do, but a person could. This is the opposite of what I'm trying to do. But a person could plead a procedural due process claim based on a state law creating mandatory predicates, I think is the word in the case law. Okay, and that those mandatory predicates were violated, and that constitutes a procedural due process violation. Okay, this case did get off on that track wrongly. Now, that's not what I intended to do with the complaint. And the complaint at the 12B6 stage doesn't contain that mandatory predicates argument or allege those facts. And so that's why I think even at this stage, this court can say that the complaint is not so defective that it should have been dismissed. What happened was that the city argued, probably cleverly, but I don't think it was necessarily a stratagem. The city argued as their main defense to this complaint is that there were not mandatory predicates, that the trespass bar statutes didn't create those. Okay, I bit on that. And then in the district court, I spent too much time talking about why the trespass bar statutes could be construed as substantive predicates. Okay, and because of that, I probably steered this case in the wrong direction. And the district court only addressed that. Okay, but before the district court addressed that, I tried to fix it in the district court by saying that the constitutional liberty interest the liberty interest at issue here is the constitutional freedom of movement interest. And, we've included in our briefs here the briefs from the district court, and I have cited the same cases that I've cited in response to Judge Stacker's questions here today, which is Kent versus Dulles and Chicago versus Morales, that there's a constitutional liberty interest and freedom of movement, and that constitutional liberty interest is the interest that we're trying to vindicate.
Are you saying that your briefing and argument modified the complaint?
No, Your Honor, I'm
Well,
not
then,
saying
if you haven't alleged that in the complaint, and I don't think you have, how is it properly before us?
Well, I believe that the only way for me to respond to that is that I believe the complaint does allege that. It says in the complaint, and of course the court, certainly has the power to say that I'm wrong, but I believe that the language in the complaint that says, quote, Henderson suffered constitutional injury as a result of defendant's impairment of Henderson's liberty interest in not being prohibited by the city from returning as a business invitee to the premises, even though it does say when the procedural due process requirements of the trespass bar statutes were not satisfied. I believe that that does identify a constitutional liberty interest. And I do say in the complaint that the constitutional liberty interest is the freedom of movement.
Yes, but you say that this is because of the requirements of Virginia Code 15-2-1717, because they were not satisfied.
Your Honor, at this stage, I believe that since this is a civil rights complaint, and that even if there's a defect in the pleading, or even if there's an error in the pleading, both the defendant and the plaintiff see what the issue is here, and that rather than dismissing Mr. Henderson's right to vindicate an important constitutional right, which he's identified, the court should treat this under its precedent of Edwards versus City of Goldsboro, that a civil rights complaint should not be dismissed at the early stage unless the facts alleged cannot constitute a plausible claim under any theory. Okay, so it may be defectively pled, but there are facts here that would allow, that plausibly support the legal theory that I'm positing now, that I posited on the brief before you. And so I request that the court reverse the district court's dismissal of the complaint on the grounds that it pled only that the constitutional interest arose from the statutes, and allow us to proceed on what we really are saying, which is the constitutional right arises because of the freedom of movement that pre-existed the Constitution and is a constitutional right, that's the source of the constitutional right. That's as plainly as I can say it.
Thank you.
Okay, I think your time is up. Here from the other side.
May it please the court, this is Tim Spencer. I'm here on behalf of the City of Roanoke in this matter. And I believe that your honors have hit on the nail on the head, so to speak, the district court also came to, which is in order to have a due process, you have to, if we look back to the Supreme Court's ruling in Board of Regents versus Roth, the Supreme Court held that in order to prevail on a procedural due process claim, a plaintiff must establish that he or she has a constitutionally protected liberty or property interest. So when you look at the pleading, the only way to reasonably come to any conclusion is that the appellant was seeking to derive his liberty interest from the statute. And when you look at the case law dealing with that, and specifically Kentucky Department of Corrections versus Thompson, Supreme Court has held that the state law must contain explicitly mandatory language, i.e. specific directives to the decision maker, that mere procedural requirements in a particularized standard or criterion to guide state decision makers isn't enough. In order for a statute to create a vested liberty interest or property interest giving rise to procedural due process, it must confer more than mere expectation. Now, when we look at these statutes, yes, I'm sorry,
Counsel,
Ron.
could I just interrupt because I think your colleague, in a very transparent way, kind of conceded the weakness of an argument that was based on statute and is arguing that he effectively pled a constitutional claim. And we can make that determination based on the pleading and in his argument. I want you, and this question shouldn't indicate what I'm thinking one way or the other, but assume we think he has adequately pled the constitutional claim. What's your response to that?
Well, Your Honor, it'd be two ways. First of all, if we look at the Dulles case, it deals with travel, and it's dealing with international and interstate, not interstate. It says nothing about the ability to remain on private property. In fact, where we did find a similar case was out of the 11th Circuit in the Watkins case, where police officers found an individual on a parking lot, and he wasn't supposed to be there. And they asked him to leave. And he sued, alleging that his due process, the same type of claim as Mr. Henderson's trying to claim here, and was saying that, hey, listen, I've got a liberty interest in remaining on that. So what did the 11th Circuit say? The 11th Circuit stated that the liberty interest in remaining in the shopping center's parking lot did not have a constitutionally protected liberty interest in remaining on that property. They further held that did not have a liberty interest in remaining on the private property, and the officers explained to him that he was trespassing, gave him an opportunity to leave. That's very similar to what we have here with Officer McLean. Again, we're going to dispute some of the facts that the appellant has alleged in his complaint. We believe he's left things out, and I think it's very important. It's hard to unsee something. If you watch the video of this incident, you see that two managers are the ones that barred Mr. Henderson from the property. So we don't even get there on a factual standpoint, which the court can take judicial notice of and is encouraged to, for the purposes of a judicial economy, to look at other cases that it has that are related. So we can do that. But from a constitutional standpoint, I don't believe that Kent versus Dulles stands for that. It's a travel case, first of all. Second of all, Chicago versus Morales, that's dealing with public property, public streets. That was dealing with a statute out of this, or an ordinance out of the city of Chicago to try to address drug dealers and gang members from gathering on public streets. Public streets, entirely different. Don't believe that it applies here. I don't believe that there's a constitutional liberty interest in remaining on private property. That has never been found. And I don't believe that this is the case in which to find it, especially when we know from looking at the facts that two employees of Walmart asked Mr. Henderson to leave and said that he was barred from the store. They have every right, and that the city's police officer wasn't acting under 15.2-1717.1, that it was actually acting under 18.2-119. Because you see, not 15.2-1717.1 is an enabling statute. Not every locality is going to do that, is going to adopt that. So what happens if a police officer shows up at a Walmart in a locality that hasn't adopted a trespass bar program, and the manager says, I want this individual to leave the store and he won't leave? Is he precluded from telling the gentleman and giving him a warning that he needs to leave, that he's been barred by the management of that establishment? I don't believe so. So therefore, as a matter of law, I do not believe that the appellant has stated the cause of action upon which relief can be granted, and therefore ask that this court support the district court's and affirm the district court's dismissal of this claim.
Was there ever an oral argument in the district court?
Yes, there was, Your Honor.
And so did Mr. Henderson's counsel make the arguments that he's made in front of us?
He did raise the issue of freedom of movement.
I understand that, but did he say that actually he intended to say that this was not based in Virginia law, but based on the Constitution?
Most of what he said, I believe that Mr. Bowman has been very honest with this court, that he argued at length that he derived the liberty interest from the statute.
Okay. I thought in response to the questions from Judge Quattlebaum that he was saying that he intended to be making a constitutional argument. But you think that's a late breaking development?
I know that he spent a great deal of time arguing with the district court on why he believed there was a liberty interest derived from the statute. I cannot tell this court that he didn't argue that, because I know that he did make mention of a generalized liberty interest of freedom of movement.
Okay. Thank you very much. Does anybody have any questions from counsel?
Nope.
Okay, thank you very much.
Thank you.
Sir, do you have any rebuttal?
Yes, Your Honor. And the last issue that Judge Motz raised, I think a fair characterization of what I argued at the district court oral argument was that I did argue there that there was a liberty interest that arose under the predicates, substantial predicates from the statute. And also at the same I also argued that it was that it arose from the right of movement arose from the Constitution. I didn't see them as mutually exclusive. I'm not sure I still see.
The court doesn't seem to have, or at least I couldn't find, maybe you can tell me where it addressed the constitutional argument.
Your Honor, it did.
Sorry?
Your Honor, the district court didn't. The district court just ignored that issue, ignored my argument.
Well, we don't have a transcript of what was argued in front of the district court, right?
That's correct. I mean, I'm telling you honestly that I did argue the substantial predicates, and I also argued the right of movement issue because I didn't see them as mutually exclusive at the time. The district court only wrote about the substantial predicates issue. On the first page at the bottom of its opinion, it explained why, I think.
Okay.
The constitutional liberty, Mr. Spencer argues the constitutional liberty interest, it doesn't extend to remaining on private property. Okay, there is a set of cases, the Hicks cases in Virginia, that are described at length in my brief. Those are about remaining in private property. So there is law, I think the law in Virginia, the law is anywhere under the federal Constitution, but it was addressed by the Virginia courts that there's a right to remain on private property, privatized property in that case. Mr. Spencer talks about this 11th Circuit Watkins versus Miller case. Okay, that's an example of how we covered these issues fully in the district court. I mean, that was briefed in the district court. We argued it, the oral argument, and this is precisely on this issue of whether there's a right of movement or not. The difference between Watkins versus Miller and the case here is that in Florida, there is a statute that allows policemen to bar people from returning to open private property. There is no statute like that in Virginia. In Virginia, a policeman cannot bar someone from returning to private property unless someone with authority over the private property bars them or gives the policeman the authority under one of these trespass bar statutes to bar them. That doesn't mean a policeman can't remove somebody for trespassing. Of course they can, but they can't bar them from returning without the permission of the private property owner. As to who barred Henderson, Okay, we allege in the complaint that McLean barred Henderson, not Shelton. I think that the video says that, indicates that. Shelton didn't say, I never want him to come back. Nobody from Walmart said that. The policeman said, I am obviously going to bar him. And the authority that he used to bar him was the paperwork under the city's trespass bar program, which is attached as an exhibit to the complaint. So I fully understand that I have maybe made this case messier than it should have been. Okay, but where we stand right now, despite having made this mess, is that Henderson's constitutional right to go to Walmart was abridged. It was abridged by the city's action. And he does not have the procedural due process that's necessary for that right to be abridged. The district court had that issue before it. We argued it before the district court. The city briefed it in its briefs, like this Watkins versus Miller case, like the Hicks cases. Those were briefed in the district court. Clearly, the constitutional issue was before the district court. Why didn't the district court address it in its decision? I don't know. Just like in the previous case, the district court didn't address the probable cause issue relating to the retaliatory prosecution claim. I don't know why he didn't do that either. Okay, but at this point, at the 12B6 stage, Henderson's right to try to vindicate his constitutional liberty interest is a significant enough interest that the court should reverse the dismissal of the case at this early stage and allow him to proceed.
Thank you very much. I guess I'll ask the clerk to adjourn court. Well, thank you for your arguments, and we're sorry we can't come down and say hello to you, but hopefully the next time you have a case in the Fourth Circuit, we'll be able to do that. So if the clerk
Thank
could.
you, Your Honors. It was a pleasure. It's been a long time. I've not been before you this court before, and I thoroughly enjoyed it and appreciate being before you.
Well, we appreciate both your arguments. Thank you. If the clerk would adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you.